We had a guy one time, heck of a nice guy, and he's probably going to be watching these tapes, so I don't want you to get offended in any way, shape, form, or manner. I'm just going to use you as an example here for the brunt of my joke. See how this goes? This guy, he's up in Montana, see? He had a little tax problem. Tax problems get real serious, especially, you know, when you're charging. This guy, I guess he makes quite a bit of money, and he had a pretty big tax liability, and he'd been convicted of tax evasion and willful failure to file and all kinds of things, but he'd served his sentence and he paid his debt to society, and poor guy's prosecuted under Title 26, and that's not even a criminal title, and poor guy is paying all these penalties and he didn't even know the tax, and I felt real sorry for the guy, you know. And so he was real concerned because the IRS sent him a letter and they said, we want you to file for 1975, 76, 77. Let's just pick 3 years. He called and he said, well, he had a friend down here had gone to school here, and his friend said, well, why don't you come on down here and see if these guys can give you a hand, you know, maybe give you a reading lesson or something and maybe help you deal here with the IRS. And so we scheduled about 5 days and we said, well, come on down here and we'll give you a crash course. And so he did, and he came down, and my friend Bob was reading over this letter from the IRS, and, you know, Bob, he's sitting there, he's reading. Hey, George, this is really funny. He handed it to me. Where's your conviction? Let me see what the judge ordered you to do. And so here's the judge's conviction, and this judge, on conviction, gave him an order. And he said, you shall do this, and you shall do that. And during the term of your probation, you shall file tax returns for the years 1979, 1980, and 1981. Oh, same thing. Did you file tax returns for 1979, 1980, and 1981? Yeah, I filed those 3 years. Oh, okay. Have you got evidence of that? Oh, yeah, right here. Here's the 3 years, 79, 80, and 81. It's 75, 76, and 77 that they want. Boy, those are the 3 years I don't want to give them. Oh, okay. Well, let's just see what they told you to do here. Bob is just reading away over here. About that time, I'm reading this IRS letter, you know. I'm laughing and scratching, just having a good time reading that. And I says, gosh, this is funny, Bob. I don't think they know how to ask the right question. They're sitting here making demands upon this guy pursuant to the court order. Can I see the court order? Yeah, George, looks like to me that the judge didn't order him to produce this. The judge says, you shall, pursuant to the jury verdict, file for 1973 and 74 and pay all taxes owed and due and owed. Well, wait a minute. Did you file for 1973 and 74? Yeah. Oh, okay. Did you pay all the tax due and owed? Yeah. Yeah, I did. Oh, okay. Have you got the returns? Yeah, they're right here. Okay. Now, the court order says you shall file for 73, 74. And during the term of your probation, you shall file for 79, 80, and 81. Okay. Well, what seems to be your problem, sir? Well, they want 75, 6, and 7. And don't you see their demand? And they're going to prosecute me, you know. I'm just really concerned about this. Why? Why are you concerned? I don't see any problem here. Boy, this guy just come unglued. He said, well, it's obvious that you dummies aren't faced with the kind of problems that I am. Oh. Well, what problem are you faced with here, sir? Well, they're gonna, if I don't produce these 3 years, they're gonna prosecute me. Well, why? Well, because it says so there. Where does it say that there? Well, it says I have to produce these. Well, who says you have to produce those? The IRS. Well, what power and authority do they have? Well, the judge ordered me to, where? Where did the judge order you to produce 75, 76, and 77? Oh, I think I'm beginning to get your drift. Yeah, it looks like to me that you've obeyed the law. It looks like to me that you filed all the returns that you were obligated to file. Looks like to me that the statute of limitations is now expired on 75, 76, and 77. And it looks like to me that someone here must have failed to charge you with not filing in 75, 6, and 7. They charged you with not filing in 73, 74. They charged you with a crime. You've paid the penalty for the crime, and it looks like now it's a whole new, another ball game. Boy, did that guy smile. He was just happy as a clam. And he said, well, seeing as how it only took you an hour to solve my problem, we don't need to pay you for the whole amount. The hell you don't. We set 5 days aside and we set an amount, and that's the contractual agreement. And that's the law. Now you obey the law. You pay us. But you can stay here for the next 5 days and we'll talk to you and we'll teach you all kinds of things for 5 days. But we've solved your problem in the first hour and a half, and so now what do you want to learn? See, the guy had been to the government schools, and just like all of you, you tend to read between the lines and you put in what isn't there. But in law, the only thing that you're obliged to obey is what the law tells you to obey. When there's an omission, it's an omission. The legislature obviously didn't intend for empty trucks to stop at the scale, or they would have said empty trucks have to stop at the scale. And it's obvious that the judge did not intend for you to file for 75, 76, and 77. He told you to file 73, 74, 79, 80, and 81, didn't he? Well, then he intended for you to file for 73, 74, 79, 80, and 81. And it's obvious he didn't intend for you to file 75, 76, 77, and 78, or he would have told you to do that. Wouldn't he? Well, what if he meant for me to file those? Well, if he meant for you to file 75, 76, 77, and 78, why don't you go back into court and tell him to issue the order? Yeah. Okay, now I'm going to tell you one more little story here, and then we'll go on to the next subject matter. I had the very same thing happen to me, only now I had learned how to read, you see. Reading is an easy lesson. Very simple. I've just taught you all I know about reading. That's all there is to know about reading. You just read and it'll tell you what to do, or it'll tell you what not to do, and if you just do or don't do whatever it tells you to do or don't do, you're within the code and within the statute. Now I can sit here and argue and say, Title 49, Judge, doesn't even apply to me. I don't have to register because I'm natural born, but if they've charged you, and you're in court, and there's this prosecutor saying, that George Gordon comes from Greece, and we want to deport him back to Athens, you better be able to walk in there and plead the code. You better be able to go in there and show you're not a Greek, because if you can't, friend, you're liable to be on the next boat out of New York on your way to Athens. All right, so you need to learn to read the code. And so to read the code, you just kind of go across and pick out the words, and you're looking for maybe, shall be, could be, exceptions. Boy, what a word. Boy, do I love except that. Because if the statute says except, let's see if there's an exception in here. Did I get an exception? Yeah, I guess I didn't. Okay, let's just take a look and run through the word exception. All persons shall have a driver's license except. And in Idaho, there's 5 exceptions. I forgot what that statute was. They charged me with that one time. And I sat there and listened to the whole prima facie case. And do you know that they forgot to prove as a matter of law that I wasn't a man from Abu Dhabi, Kuwait, or Oman? That's right. It says all persons in the state of Idaho who have resided here for 90 days. They didn't even prove I resided here for 90 days. They assumed that I was a resident, but they didn't know that. And so I waxed a little eloquent and I said, Your Honor, they failed to show that I meet the residency requirements. In order to be a resident of Idaho, you've got to be here for 90 days according to the statute. Now, there's been no evidence and there's been no testimony to show that I'm a person who's lived in this state for 90 days. It says here that except, now look at these exceptions, except persons operating farm equipment, tractors, combines, and other self-propelled tractors. There hasn't been any testimony by anybody that I wasn't operating a tractor at the time this officer stopped me. And look at this exception. Except persons on duty in the military services. There hasn't been any testimony or any evidence whatsoever, Your Honor, that I'm not a person who's in the Air Force down at Mountain Home. Well, it's for these reasons, Your Honor, that this statute fails and the code fails, and the prosecutor has done a marvelous job of proving that I don't have a driver's license, but what he hasn't proved, and what he's failed to prove, I should say, Your Honor, is that I'm a person who's even required to have a driver's license under this statute. And there was another victory for me, and many of our students have done that. They've kind of stopped here around our local area charging us with this driver's license, because now as a matter of law, you know, can you compel me to sign a contract? You're going to point a gun at my head and tell me, sign this contract. Does that make the contract good? Does that fall into the testatrix formula on page 458 of the Miranda Doctrine? Okay. All right, so there's a reading lesson. Now, if you're talking about what is and what is not law, pursuant to the statutes, then it isn't law if it doesn't tell you to do it, and it is law if it tells you to do it. If the statute says to do something, you know, you've got your pen, you've got it in your pocket, and the statute says to deliver the pen over to the officer. Okay, officer, I'm going to deliver the pen over to you for your inspection. Then you fall within the statute, and you have to obey the statute. What if you're a person who is not even subject to the statute? The officer says, deliver the pen over. And the statute says, except, or the enabling statute says, except, or the Constitution of the United States makes you an exception. The persons who are required to obey Title 49 are all of the subjects that the sovereign legislature or state of Idaho has control over. Corporations, trusts, foundations, all juristic persons, all persons who are acting in a capacity, or a corporate capacity, they have to have driver's licenses. Okay? So let me run over the list and show you who has to have the driver's license, and you can apply this then to any particular law, any particular set of statutes. But let's take a look at who must have a driver's license before we talk about who's exempt from the statute. We're going to talk about who has to have the driver's license or who has to conform to the particular statute. You have to go back to the enabling statute and find out whether or not you're a person who comes within the subject matter of that title. Now, the driver's license has been used since 1913 here in Idaho. A couple of days ago, I took a petition for a declaratory judgment out to John Rooney, who's the director of law enforcement here in the state of Idaho, and there was an attorney in the office, and when I presented him with the brief, it just blew his mind. He was sitting there, and well, actually he was standing there, and he read that, and he was just incredible that I would seek a restraining order against the Idaho State Police to prevent them from arresting me and putting me in jail or giving me traffic tickets for not having a driver's license. They just couldn't grasp that. It's like trying to get a restraining order to stop me from robbing a bank. You know, if I'm in the process of robbing a bank and the policeman catches me in the act as I'm running out the door, I say, hold it, officer, this is a restraining order. You can't arrest me because I'm robbing this bank. And, you know, that's the way they see that. What they fail to understand or what they fail to see is what the intent of the law is. On the one hand, we've got common law crimes, and a common law crime under the 222 rule then, as we've described it here, is a crime or a law, it's a violation of our common law that's been recognized for thousands of years. It's a violation of the Ten Commandments. It's thou shalt not steal, and you're over here stealing, you know, so stealing is a crime. And so they'll turn around and say, well, thou shalt not sell whiskey. And so they just pass one of the king's statutes and they say, okay, from now on, 1920, from now on, whiskey is illegal. Now, it's been legal for 3,000 years up to 1920, but beginning in 1920, we'll put you in prison if we catch you drinking whiskey or buying, selling, and trading whiskey. Then 1933 comes along, and then the king changes the statute. Okay, now whiskey is legal again. All right. What we're talking about here then is who is it that's required to obey the statute? Who's required to obey this law? Not all statutes, not all laws apply to all persons at all times. It's a very simple premise in law. Now what I want to do is I'm going to start out, now let me just give you a little explanation. I'm going to read Marbury versus Madison to you on that very subject matter. Let's suppose that you owned your truck, free and clear, absolutely didn't know a dime on it, threw the license plates away, threw your driver's license away, and you've got this truck and trailer, you own it, it's your allodial freehold property, and now you want to haul your hay from point A to point B. The road out there, as a matter of right, you have a right to use. That's part of life, liberty, and property. Remember, liberty is the capacity to will yourself to move from point A to point B and be uninhibited by your government. And so you do that. You're not subject to Title 49. You're not subject to the law. You're using your constitutional right to life, liberty, and property then as the basis, and you're not the basis for your actions, and you're not encroaching upon any public interest. You're not affecting a public interest. You're not in interstate commerce. But take a look at Garrett Truck Lines as an example. Can Garrett go out and throw the license plates off their truck and drive it down the road with an employee-type driver? And here he is. This company has a special privilege. They have a monopoly over a particular route. Or they have a right to serve people. And when you walk into Garrett, it doesn't make any difference whether they like you or not. They have to take your box and they have to take it to Pocatello, whether they want to or not. There's no, they do affect the public interest, and there's no interest here in private contract. All right? The proper subject matter then for our legislature to regulate Garrett in the public interest under the police powers is obvious to all of us. We don't want those guys driving up and down the road at 90 miles an hour, pulling 3 trailers and endangering our lives, and then not have insurance on their trucks in case we have an accident. We want that paper entity to have the capacity to pay us for our damages. There are no rights that belong to a corporation. And over here in Hale versus Hinkle, remember, we're of the opinion that there's a clear distinction in this particular between an individual and a corporation, and that the latter has no right to refuse to submit its books and papers for an examination at the suited state. In every case that I've ever seen from the Supreme Court of the United States, when they're dealing with a case of a corporation, they don't have any rights. They just don't. They just laugh at the foolishness. And you know, there's lawyers coming into courts all the time, and they don't understand this Hale case, and they think that corporations and individuals are one and the same person. And that's where you have to make your distinction. When you're reading a Supreme Court case, who is the case addressed to? Now, let me give you a couple of classic examples here. When you're reading Almeida Sanchez, the government came into the courtroom in the Sanchez case and said, well, we've got a right to stop him and search his pickup. And the court said, no, you don't. That man's got rights protected under the Fourth Amendment. Didn't the government prosecute a, quote, Colonnade Catering Corporation in Biswell versus U.S.? You see, there are some cases where Colonnade Catering and Biswell were corporations. And of course the corporation that's engaged in trade, commerce, business, or industry affecting a public interest in inter- or interstate commerce can be regulated. One of them was in the alcohol business, and the other one was in the gun business. And they knew that there would be inspectors come in. Doesn't the bank expect the bank examiner to come in every month? Can the bank say, well, we're going to invoke our Fourth Amendment rights and protect our persons, houses, papers, and effects? Balderdash. The bank's going to open its records, and all of those bank officers are going to be responsible for any shortages that might be there. And they're going to obey all the rules and regulations set down by Congress and set down by the legislature. Because that legislature and all the agents of the government are the proper authorities to regulate that bank. Then the regulators, not understanding your constitutional rights, apply those rules and regulations upon you. And they have expanded the law into areas that it doesn't really apply. See, it doesn't apply to you. Your persons, houses, papers, and effects are private, protected by the Fourth Amendment. The bank has no right or expectation of privacy. Beginning to see now where when you have a checking account, you don't have any right or expectation of privacy. Those checks belong to the bank. That's the bank's property, and they have no right or expectation of privacy. So what the court has done, like in the Barlow case in Pocatello, they've muddied the water. Barlow was a corporation. Barlow was always subject to regulation by government. And so now the court has split hairs. They've said in the Barlow case, well, if you've got less than 100 employees, well, we're going to recognize that as a person. And what you're doing is you're getting a blending or a melding here of individual rights and persons with corporate entities. Personally, I would rather they just separated them pursuant to the Hale Doctrine. Because now what they're saying here is that, well, if it's a corporation and it's under 100 employees, or because of certain rules and certain regulations, we're going to give them some of the rights of an individual. I'd rather give the corporation no rights whatsoever, and let's separate the two of them the way we've always done it in the past. Actually, I think the Barlow case was a bad decision, and it's going to be more harmful to us in our individual rights quest than it would have been without it. But nevertheless, the citizenry doesn't understand the difference between a corporation and an individual. The schools don't understand the difference. And they go, then they educate us in these government schools, and then, of course, the lawyers go to law school, and they've been to the high schools, and nobody seems to understand the difference between rights and privilege. And they just seem to think that, well, driving on that street out there is a privilege. Well, of course it's a privilege when you've got a license. Of course it's a privilege to deal in alcohol when you're licensed. And of course it's a privilege when you're driving on the roads with a Garrett truck. But when you're the natural person, when you're the son of the owner, the son of the father, not one of the mere servants or one of the subject slaves or members, you don't need the license. And if you volunteer to get the license, then what you've done is you've volunteered into a regulated enterprise. So says Almeida Sanchez and Delaware versus Prowse and Colonnade Catering and the Biswell case. When you put those cases together, you'll find that the Supreme Court is telling you a story. Sometimes you have to put 4 or 5 of them together. And I learned this some years back when we were looking into, say, Scripture. And you want to understand a topic in the Bible. Let's just pick one, like baptism. Go look up the word baptize and baptism and baptized and look it up in Strong's Concordance, and it'll appear in there 30, 40 times. Then you take those 30 or 40 statements or scriptures on that subject, and you can get the whole story. Everything that the Bible has to say about baptize or baptism or baptized is right there in front of you. I just extrapolated that and applied it to the Supreme Court. You want to find out what the Supreme Court has to say on a particular subject? Let's take contempt of court. Go look up contempt in words and phrases in the law library. And all of a sudden, or like I did, or I think I've mentioned this before, like Social Security. Look up Social Security. There's 132 cases, and you just go through the syllabus, and you say, well, here's what the court has ruled on in 132 cases brought pursuant to the Supreme Court, or pursuant, rather, to Social Security as it's been brought to and decided by the Supreme Court. And that's the way you do that. So they're applying law then to us it's gone beyond the intent of the lawmaker and gone beyond the bounds of our Constitution. And that's then under color of law. They're acting as if it were the law and as if the law applied to you and as if you're a person who's required to obey this. The policeman comes up and he says, I want to see your driver's license. He's taught to ask that. He doesn't know why he asks for a driver's license. I'll bet you there isn't one policeman in 100, if you ask him the question, why do you want the driver's license? What reason, what lawful constitutional need is there for you to see a driver's license? And what he really should say is, I need the evidence of your voluntary consent into a regulated enterprise, otherwise I don't have any jurisdiction or control over you. I don't know whether you're a person who's required to file this tax return until I first see all of your records and documents and books, and I can determine if you have any income. I'm not a taxpayer, I don't have any income, and that's why I didn't file. Poor IRS agent sitting up there going, this just can't be. Everybody has income. Why? Who told you that? What evidence do you have that I have income? Well, we've got these W-2 forms. That's the evidence that somebody paid me some debt notes. That's not evidence of income, because that's not the definition of income. And who decides what income is? Well, the Supreme Court of the United States. In Bouvier's Law Dictionary, in Black's Law Dictionary. You've got to put some words and phrases together so that you can understand the total subject matter. Most IRS agents that I've ever talked to, with one or two exceptions, don't understand income compensation. They're accountants, and they've been to accounting school, and to them, if you give the guy the pen, that's income. Doesn't make any difference how you got it, that's income. And we're going to put a value on it. All they recognize is numbers, and of course they're trained in that business. They're not trained in law. They're not trained in the Supreme Court's decisions. All right, so there's your undercolor of law, and there's the type of person who wouldn't need a driver's license. An individual doesn't need it. An individual has a right to make a living. You have a right to work. You don't need a Social Security number. You don't need government's permission to work. Now, Garrett needs government's permission to work. Corporations and all other types of juristic persons will need the government's permission to work. So, if you're a natural person, you have your constitutional rights available to you, but you probably don't have them because you've waived them. You haven't demanded them. And there's where your problem is. Okay, now we've covered that before. Let me take a look here at Marbury versus Madison. And I don't know if you've got this case or not, but I think in some of your books by this time, and as I'm doing this tape, I don't know what you have in front of you, but we'll see to it that you either have it in the books that you've already received or that you'll get Marbury versus Madison with this lesson. I want you to pick up Marbury versus Madison, which is called First Cranch. That's 1C137, where it's 5 U.S. 368. That's the code number to find it. So if you go to the law library and you want it, you'll need those numbers. Turn over to page 388, I believe it is. Check over here and see, 388. I want to read through this with you. I want to show you. This case is decided in 1803, and I want to show you that this is the law of the land, and it's still the law of the land, and our Supreme Court quotes from this case constantly. You know, when you're reading through a number of Supreme Court cases, and I would assume that by this time, this level of understanding, that you should have read 100 cases in Search and Seizure Law Report, and you should by this lesson now have a good understanding of the subject matter of search and seizure. And by now, you should have read a number of other Supreme Court cases that you've received in these books 1 through 6, which are called Supreme Court cases or Supreme Court decisions. And you should have read Miranda versus Arizona and Almeida Sanchez and Terry versus Ohio and those cases. And if you did, by now you recognize a lot of names keep reappearing, don't they? In other words, you can recognize now that Miranda's name appears, Escobedo, Carroll, Silverthorne Lumber, Boyd versus U.S. You see, those cases keep reappearing. And you've probably seen Marbury versus Madison from time to time when we're talking about which is superior, the Constitution or statute. All right? Now, the Supreme Court, remember, does not go into chambers and say, okay, fellas, let's take a vote. And they go around the corner here like a democracy and vote. What they do, they discuss a case, or they'll take the facts of the case, and then they'll say, well, what do you think? Shall we accept the case? And they'll take a vote on that. Yeah, we'll accept this case. Let's make a decision. And then it'll come out 6-3, 5-4 in their straw vote and say, yeah, well, here's the way I see this. And then like a jury, they'll bargain back and forth, and they'll haggle it, and they'll talk about cases, and those people will change their minds from time to time. They'll say, well, based upon Marbury and based upon this case and based upon Terry and based upon our decisions in the past, if we don't rule in this case based upon this set of facts and these laws and these Supreme Court decisions, we'll be overturning what we've been saying for years and years. An example of that, just to give you an idea, would be maybe the plain view rule. All right? If you'll look in Black's Law Dictionary under plain view rule or under evidence, you'll see that there's a topic or a subject matter called the plain view rule. And if the policeman has a right to be where he is at the time he sees the contraband or the evidence, he can seize it and it can be used against you. But if the policeman doesn't have a right to be there, That is, let's say he walks up, breaks your door down, goes in the house, searches all over, he finds the contraband, comes back out. That's the fruits of an illegal search, and that evidence will be excluded from the trial. All right? What if the Supreme Court were to say, yeah, that's legal evidence, we don't like drug pushers, and the policeman broke the door down, and sure, that was bad, and we've always ruled in the past that you shouldn't do that, and we've thrown the evidence out in the Weeks case and in Boyd and Silverthorne and a number of others, but in this case, we're going to rule that we're going to allow that evidence in. That would have been the Almeida-Sanchez type case. We're going to allow that marijuana to be used. Then they would be overturning dozens of other cases that have already been ruled along the line pursuant to the Plainview rule. All right? Now, that being the case, then the Supreme Court then would be like our legislature. It changes with every wind of doctrine. I mean, you've got pro-abortion and anti-abortion people running around now, and they're all out here blathering about, well, this or that or something else, and I don't care what your particular philosophy is on abortion, so, let's not get bogged down on philosophy. I'm just telling you that as a matter of law, the case has already been decided. It's decided pursuant to the Constitution. So if you're pro-abortion, everything's going along hunky-dory, and if you're anti-abortion, you need a constitutional amendment. That's what it boils down to. The subject matter, though, that the court is going to always determine is, here's the statute. This is the way it works. Here's the statute, and we're going to set that down next to the Constitution. And we're going to listen to the two arguments. The one side says, I don't need the driver's license, and here's why, and here's a whole line of cases that you've already decided. And the government's going to say, here's the law, here's the statute, here's the police powers, and here's what you've decided pursuant to police powers. And then the court's going to sit there and make a decision, and they're going to apply the law. If I'm right, they're going to say, Gordon, you don't need a driver's license, and that's the way we've been ruling for years and years. I'm not trying to overturn the driver's license law. I'm not challenging the driver's license law. What I'm challenging is the driver's license law as it applies to me. Just me. I don't know about you, and I don't know about the other 230 million Americans out there. Maybe the other 230 million need driver's licenses. I don't know. But pursuant to the Supreme Court's decisions for a number of years, I don't need one. And I don't want one, and I don't want to waive my rights, those rights that I have to waive in order to have that privilege. I just don't want that. All right? That's the way the court rules, and that's the way the court works. And that's, I don't know if it's good or bad or right or wrong. It's been going that way now for 200 years, and I'm content to say that with the exception of 5 or 10 cases that I've read, I think the Supreme Court rules pretty correctly most of the time. Now, maybe I'm a little off base, and maybe the Supreme Court rules better than I think it does, or not quite as good as you may think that I think it does. But that's a matter of opinion, and we don't want to get involved in opinion. What we need to do is analyze, how does that court work? Now, once you know how the court works and you've read a number of these cases, you can conduct your life in such a way that when you do an act or do an omission, see, I have total confidence that the Supreme Court of the United States is going to uphold my position on the driver's license. If I didn't, I'd go get a driver's license. Now, since I'm convinced and I've researched it and I know where I stand, then I'm prepared to go to Washington. Fellas, do you remember what you said in Marbury? And hey, fellas, do you remember what you said in Sanchez? And hey, fellas, do you remember what you said in Miranda? Do you remember Crandall versus Nevada? And now I'm going to go through a dozen cases, and I'm going to say, remember Hale versus Hinkle, where you said there was a clear distinction between corporations and individuals? There isn't any evidence that I'm in a corporate capacity, and I'm claiming that I'm an individual. And I want you to remember that. See, that's what I'm going to do when I get to Washington. When I plead the statutes, remember, I'm starting way down here at the traffic code, and sometimes I'll plead the code, and sometimes they'll dismiss, and sometimes I'll win on a technicality. And it never goes to the Supreme Court, does it? When the state finally gets its act together, and they keep arresting me, and I can establish a long train of abuses or a long train of events, then I can go into the court and petition my district court then for a petition for declaratory judgment. Now, one of two things is going to happen here. Either the court, that is my district court in my local area, is going to uphold my position, or they're going to rule against me. If they uphold my position, George Gordon won't need a driver's license in the state of Idaho. It doesn't do a thing for me over in Washington. It doesn't do a thing for me in Nevada. But in Idaho, I'm going to have this piece of paper running around. Hey, officer, that's right, there's no license plates on my car, and here's why. And it won't take them long until they get the word around the state that there's a class of persons that don't have driver's licenses. It's just that nobody's ever done this. It's just like the blacks riding the back of the bus. You see, it's just that nobody had ever challenged that law. Been there for 136 years. And that's where we are when we come down to looking at the Supreme Court then as it applies to us in our particular individual, everyday garden variety way of life, whatever it is that we're doing and however we're living our lives. When you get down on that bottom line, it's how does the Constitution apply to me in my case? And that's why I keep telling people all the time, you know, some of you people out there are tax evaders. You owe that income tax. You've availed yourself of the privilege, and therefore you must pay the tax. I don't ever tell people that they can evade taxes or that they can just go out and break the law. The police seem to think that I'm breaking the law because I don't have a driver's license. But I'm making what's called the good faith challenge. And whenever you're making that good faith challenge, you know, the assertion of a constitutional right cannot be converted into a crime. So says legal quotations here. You can take a look at that for yourself. I've read it to you before. Can't say that I'm breaking the law and I'm a criminal because I don't have a driver's license. And nor can they do that to you. When you're pleading the code, remember, you're trying to win your case. And so when you're pleading the statutes, when you're reading and looking for loopholes, you don't necessarily have a constitutional issue at that level or that stage. You might have to go through 5, 6, 8 times on a particular subject matter. Maybe it's only once, like the lady riding the back of the bus. That was a pretty carefully set up type challenge. Or like in my case, sometimes they just dismissed. And if the government dismisses the case, you win, they lose, but the issue has no constitutional ramifications at that point in time. All right, now if you've got your place here in Marbury versus Madison on page 388, let's take a look through here, and let me show you how the Supreme Court of the United States is going to look upon the difference between statutes and the highest law of the land, the Constitution of the United States. So let's begin here with Marbury versus Madison. Starting here on page 388 in the center of the page where it says that the people have an original right to establish for their future government such principles as in their opinion shall most conduce to their own happiness is the basis on which the whole American fabric has been erected. The exercise of this original right is a very great exertion, nor can it, nor ought it to be frequently repeated. In other words, here's your Supreme Court saying we don't need a revolution every so many years. What we want here is law and order. We've got to have a system. And this whole American fabric that it's been erected on is designed around this thing called law and this thing called our Constitution. The principles, therefore, so established are deemed fundamental. And as the authority from which they proceed is supreme and can seldom act, they are designed to be permanent. So here's your Constitution designed to be permanent, cast in cement, so to speak. This original and supreme will organizes the government and assigns to different departments their respective powers. It may either stop here or establish certain limits not to be transcended or gone beyond by those departments. Here's your government. You know, here's God, man, the Constitution, government, and the bureaucrat. All right, so they're simply saying, we recognize that the people, the sovereigns, that's you and I, set down this contract, cast it in cement, and said, this is the law of the land. Now we're going to organize some limited powers for the government, and then those departments of government will exercise those limited powers. Not absolute power over us. The government can never have more power than we, the people, have, that we can then delegate to our government. You can't create something greater than yourself. This The government of the United States is of the latter description, talking about a subject matter at the top of the page. The powers of the legislature are defined and limited. I want you to note that word limited. The powers of that legislature in your state are defined. And they're defined in the Constitution of the United States and in your state constitution. And they are limited powers. Now you tell the policeman that or the bureaucrat that, and he'll look there and go, hey man, you just are out of it. I don't think you understand the law. That's what they tell you. They say these statutes here are the law. And you've got to obey the law. And you sit there and say, well, wait a minute, son, let me explain to you how the Supreme Court's decided that. And they get mixed up and they get confused right away. Try that on a bureaucrat. You tell him that the powers of the legislature are defined and limited and see if he gets confused. I promise you he will. And that those limits may not be mistaken or forgotten. The Constitution has written. How much plainer can you get? Here's your Supreme Court saying, so that you dummies can't forget the terms and conditions of the contract, we wrote this Constitution. To what purpose are powers limited? And to what purpose is that limitation committed to writing? If these limits may at any time be passed by those intended to be restrained. Let me tell you, those legislators up there in our legislature in Idaho have never heard of the Constitution. They just pass laws willy-nilly. Not only are their laws oftentimes unconstitutional, the acts that they create to carry out those laws are made as if they're the lawmakers, the lawgivers, as if they're God, and they're handing down decrees for the subjects to live by. They literally live that way in Idaho. They have no concept whatsoever of limited government in Idaho. They are God in their eyes. The distinction between a government with limited and unlimited powers is abolished if those limits do not confine the persons on whom they are imposed, and if acts prohibited and acts allowed are of equal obligation. It is a proposition too plain to be contested that the Constitution controls any legislative act that's repugnant to it. The Constitution, then, when an act that is repugnant to that Constitution, that law then is null and void. Or that the legislature may alter the Constitution by an ordinary act. Well, they do that every day here. I mean, they just abolish our Constitution. They just pass laws here, and that law is the law, and the policemen carry out these laws, and they don't take any cognizance or notice of the Constitution whatsoever in Idaho. Now, I don't know about where you live. I have a sneaking suspicion that up in Washington State it's worse than it is here in Idaho. These people act like absolute little petty tyrants here. Now, down at the bottom of the page, between these alternatives there is no middle ground. The Constitution is either a superior paramount law unchangeable by ordinary means, or it's on a level with ordinary legislative acts, and like other acts, it is alterable when the legislature shall please to alter it. I agree with that. Either the Constitution is superior or it's inferior. Now you can sit there and say, well, I think it's inferior. Well, okay. Or you can sit there and say, well, I think it's superior. I think that the Constitution is a superior law to an ordinary statute. Okay. Well, let's see what the Supreme Court had to say about it, because they're the fellows that count. If the former part of the alternative is true, then the legislative act contrary to the Constitution is not law. If the latter part be true, then written constitutions are absurd attempts on the part of the people